So look, just to kick things off, one of the first things that I wanted to do in order to start off this webinar is really to talk about the duties and powers of shareholders, directors, and officers. We get a lot of founders that come to us that have these great ideas that they really want to basically implement and do some really good work in the world and to have a large impact. And one of the things that they always come to us is they ask us, "Hey, we're gonna start this entire crazy journey. So what should we start with?" And for us, and for most people, the most common legal vehicle to use and the one that is most recognized in the industry is just a limited liability company, and specifically a New Zealand limited liability company. And the process is quite easy to be able to incorporate a company. All you have to do is just go on the company's office website and you just follow their instructions, pay a few fees, and then you're done. So that aspect of the process is not something that we get questions about. It's actually what happens after a company has been incorporated and they're starting to do work. And one of the first things that we like to educate our clients and founders about is the importance of different hats. Often, what happens in the startup ecosystem is that you will have one person be the main shareholder or the only shareholder, and that same person is also the director of the company, and that person is also the CEO, which is the chief executive officer, and most likely everything else as well, because it's a startup. They have to do everything and anything in order for that company to grow. Um, we try to be very informative and educational about the different roles and responsibilities of all of these hats that the same individual is wearing. So there are different duties and responsibilities and potentially personal liabilities that can attach in an individual's performance of each particular role. Now, the first one is the shareholder, and the shareholder is basically the person that owns the company. So, as a shareholder, there are very few actual liability and duties that you owe to the company. They only arise in very, very specific circumstances, most of which are quite rare. So when it comes to shareholders, if you are making a decision as a shareholder, so for example, if you're going to be signing a shareholders resolution or in a shareholders meeting, you pass a resolution to make the company do something, there's usually not much risk attached to that particular action. Now,
And can I just jump in
sure.
as we go? We'll just kind of pepper in thoughts as we go. Just to mention there, that's why they're called limited liability companies,
Mhm.
because the liability is limited. As a shareholder, you put in some funds, and the funds then are used to start the company and to get it going. But basically, the shareholder then lets the directors and the management continue on, which are these other hats that you're talking about. So
Exactly, exactly.
just always and remember, a couple hundred years ago, there was no such thing as a company. They're relatively recent inventions, and they're set up to encourage entrepreneurship. So instead of you starting a company, it doesn't go well, you lose everything. Today, you start a company as a shareholder, you put money in, you'll lose what you put in, but you won't lose everything else. So just a couple points to give some color to what you're saying.
That's exactly right. Yeah. And so that brings us now to the director's hat, where a person is acting in their capacity as the director. Now, this is um, a very legally fine point. Within the Companies Act, there really is no specific definition of what a director is in terms of if you do this, then this happens. Under the Companies Act, the directors are the people that direct the company. So you can almost sort of think of it as sort of a circular definition. So you have to be careful whenever you are making decisions to sit and think, is this the role? Is this decision something that a director of a company would make? And that is something that is very important because whenever you're acting as the director of a company, there are certain duties that attach to to you and that you have to abide by, or else you risk basically breaching those duties. And then because you breach those duties, you are potentially facing liability vis-a-vis the company or potentially the shareholders through a shareholder derivative action. So this is my personal little Bible of the Companies Act. As you can see, it's quite thick, and this is only one of two. But the place that we would like to go, I'd like to go in and talk a little bit more, is about the specific duties that a director owes to a company. Now, these are found in section 131 to 138 of the Companies Act, and they are under section 131, duty of director to act in good faith and in best interest of the company. 132 is the exercise of powers in relations to employees. 133, powers to be exercised for proper purpose. 134, directors to comply with act and constitution. 135, reckless trading.
That's one of my favorites.
Yeah. 136, duty in relation to obligations. 137, duty of care, director's duty of care. And then 138, use of information and advice. Now, for today, and actually for most of your activities as a director, the ones that really you're going to have to think about these duties all the time. But typically, when you're making a decision as a director, if you can justify your actions under these duties, then you basically are in a good position. Now, that literally means that the Companies Act gives a bit of flexibility and deference to directors for them to be able to make their decisions. The Companies Act is not going to tell a company director, hey, in circumstances A, you must choose this particular path, because each circumstance is going to be very different. And so even the guidance and the specific language that is stated in the Companies Act legislation is not going to be specific at all. These are generally general concepts that you have to take in and act in accordance with. Now, there's obviously a lot of case law behind each of these duties that specify and are able to provide more detail as to what it means to act in good faith and in the best interest of the company. What does it? Yeah, go ahead.
I was just going to say, I have two questions. One is, I would love to hear after this part, Emery, why you love that duty so much. So be prepared for that. And I'd love to have a little discussion about like Mainzeal maybe as well.
That's
as
right.
a case. But the second question I got, Yang, is how long are these duties? Like you've held up this book. It's quite long here. How many pages are the duties? Because I think that's worth emphasizing.
Yeah. Yeah.
It's literally, what is it, 2-3 pages?
That's right. It's very, very, very short.
So it doesn't, as directors, it wouldn't take you long to go find sections 131 to 138 and have a look at them. Lots of, that's a lot of content, but it's actually the guts of your duties is literally 2 or 3 pages. So
that's 100% correct. And look, the reason why the duties are only a few pages is because the Companies Act is not trying to put handcuffs on company directors in terms of the freedom of actions. It's basically guiding principles and making sure that company directors, when they act as directors, that they have these responsibilities at the forefront of their mind as they're making these decisions. That's part of the due diligence and of the good faith that you have to undertake in order to make a decision that is defensible and that is hopefully recorded and written down to help with that, to help with any future challenges if they do come.
Yeah. And I think, to add to that, the law often is written to protect people. And if we think back to what Yang was saying about shareholders invest their money, and it's incumbent on directors to behave appropriately in terms of how they manage the company, to look after the investment by those shareholders. So it all really is quite logical.
Yeah, so Anne-Marie, why don't you tell us a little bit more about sections 135 or 136 and the recent case law of Mainzeal and how this highlights the personal risk that directors can have in fulfilling their role.